Thank you very much to everyone of you present today, online, on site, a lot of participants. My name is Matteo Falmedia again, postdoctoral assistant and assistant professor at Tufts University. So it is also a warm welcome from my side with this shiny day, actually in Hasselt, against all odds. It is my pleasure, together with Ivano Aronia, to introduce this roundtable. The purpose of this roundtable, which very much boils down to the comparative aspects of climate change litigation, in fact, comparative perspectives, is actually to embrace the different insights that will come from 5 different European countries. So Belgium, France, Germany, the Netherlands, and the United Kingdom. So to this end, we have actually 6 distinguished guests from these 7 countries, who I would like to introduce in a minute. Before that, however, I would like to point the rules of the game. Essentially, we're going to go for 3 rounds of questions, and we're going to give 5 minutes time to each of the speakers to answer to this question. And we're going to be very much Teutonic in this respect. So 5 minutes sharp. And of course, Q&As from on-site and other participants would follow. So first, I will move straight away to the 3 of the speakers that we have today. First of all, Carole Beget, again, is of course professor of environmental law at Tufts University. Used to be affiliated also to the Center for Environmental and Energy Law at the University of Ghent. And more importantly, I think for the context of this specific roundtable, she has, let's say, an in-depth knowledge and actual, let's say, insight on the Belgian climate case, Klimaatzaak, which she is currently litigating. Moving very briefly to our next speaker. Next speaker will be Rhoda Ferrari from Germany. I don't think Rhoda needs a specific introduction in this room. However, I would like to point out, of course, that she has been is joined the Friends of the Earth International campaign. He has also worked for the Federal Ministry of the Environment, Friends of the Earth, German Watch. She's of course a lawyer, and she's also joined the German delegation to the UNFCCC. And of course also is joining the Network Climate Justice Program. She has published quite extensively on climate change litigation and has litigated one of the most appealing cases in my view, at least in Germany, the Yuya versus RWE case. So perhaps we'll hear more about that later. Last is Sarah Med. Sarah Med, who unfortunately cannot make it here today because of the storm, is Senior Legal Associate at the Climate Litigation Network, which is, as you know, probably a project which was funded and run by, the Agenda Foundation. She is also co-lead of a project on the World Commission on Environmental Law, whose title is Judicial Handbook on Climate Litigation, and co-editor of the forthcoming collection, The Environment Through the Lens of International Courts and Tribunals. So with this, I will hand over to Ivano to present our next speakers, and then we can start with the roundtable.
Thank you, Matteo. It's great to be here with all of you. Thanks to our colleague from Tufts University for this great job they've done helping us organizing all this, and especially for the job they've done physically here. And so I'm Ivano Aronia. I'm the Arthur Watts Research Fellow in Environmental and Climate Change Law at Beget. So you already heard about this. And in exactly 1 week, I'm also lecturing and finishing my PhD at Sorbonne University in exactly 1 week. So just to say, very important moment. And so thank you very much for being here. I just introduced the male counterpart of this panel. Let's start with France. We have Sébastien Mabille and François de Cambière, who are French lawyers representing NGOs and communities in some of the most compelling climate litigation cases in France, developing notably an expertise in corporate social responsibility litigation based on the duty of vigilance law adopted in France in 2017, as you know. They have brought cases against French oil major Total on climate change, against Casino for its contribution to deforestation in the Amazon, representing French and international NGOs. So they are behind Notre Ferratus, Sherpa, Mighty Earth, South American NGO Coalition, and many others that we don't have the time. In particular, let me give you some details about them. Dr. Sébastien Mabille has also worked for more than 20 years on the interplay between law, biodiversity, and climate. He is currently vice president of the French committee of the IUCN and member of several think tanks and expert groups. Sébastien has advised major local authorities in cases with high media, financial, and political stakes. For example, Erika, climate suit against Total, as we will see. And he teaches environmental law at the School of International Affairs at Sciences Po Paris and at the University of Aix-Marseille, and is member of the Environmental Club, Lawyers Club. François de Cambière has been a lawyer in Paris since 2011. He specializes in strategic litigation, white-collar crimes, financial opacity, and tax evasion, and more generally in corporate social responsibility. François is a founding partner, along with Sébastien, of the law firm Seattle Avocat. He advises and defends before the court leading French international groups, as Sébastien, as well as NGOs. Working for companies and NGOs allow him to develop a balanced vision of environmental and social issues while working to promote the respect of the law by companies. To finish, François also lectures corporate social responsibility and climate litigation at ESSEC Business School. It is an expert of its European Center for Economic Law. Let me introduce you now our speaker from the UK, Nigel Plamm, Queen's Counsel. So Nigel Plamm has a distinguished legal career spanning over 50 years. He's a British myth. Nigel was called to the bar in 1971 and appointed a Queen's Counsel in 1992. He practices mainly in England and Wales, but also in Hong Kong, Belize, and the Caribbean. He's been recommended as a leading Silk in the Legal 500 since 2000 in the specialty of administrative, public law, civil liberties and human rights, environment, practically everywhere. I cannot continue because it's really long. Nigel has been a deputy judge of the High Court and a judge of the Courts of Appeal of Guernsey. He's a barrister throughout his career, 39 Essex Chambers, a role taken up in 1973. He's, of course, he has a special interest in environmental law and recently acted with others for a coalition of resident local authorities and green groups, including Greenpeace, in the well-known challenge to the government decision to authorize the building of the third runway and sixth terminal at Heathrow. I'm sure that everyone heard about this. Nigel is also our honorary senior fellow at Beget, where for the past 2 years has been involved in our activity in the field of environmental climate change law, putting his skills and passion to use for event and research. And he also authored a chapter in our book on the United Kingdom, the book that Beget published on climate change litigation in global perspectives. So I would say it's fine. I leave to Matteo.
Yes, thanks, Ivano. Just to recall, we are going to ask you to answer the questions in turn as per the program. So we will start with Carole Beget, Belgium, then Sébastien and François from France, then Rhoda from Germany, then Sarah from the Netherlands, and last Nigel from the UK. So the deal about this roundtable is precisely to run through the key, let's say, pitfalls and benefits of national climate change litigation, and we will do this through a threefold perspective. So we will look at it from the past, from the present, and from the future. The whole deal about this conference is indeed to look at what we have achieved so far, but also to take a look at the future of climate change litigation. So in this respect, the first question I want to ask to our distinguished panel is about the past, so to speak, of climate change litigation. And the question goes as follows. Is climate change litigation, both against public and private entities, actually relies upon a patchwork of legal bases, right? We have discussed this before, ranging from human rights to public and constitutional law to private law tools. So the question is, which legal tools have proven the most successful in your legal system in terms of upholding your arguments before national courts? Carole Beget, the floor is yours.
Matteo and Ivano, when you sent this question, I was really thinking, what will I answer? First of all, what is success? We join there what was said by Judge Aker and by Mark Withers. There is so much also around the case. For instance, just the Belgian climate case, it set out in 2014 with 8,000 citizens. It was heard in court with more than 58,000 citizens. So the movement of mobilization of people in this kind of thing is a factor also, I think, that matters a lot. But if we strictly look at the legal machinery, also there, the question raises, how can I answer this? Because you cannot isolate whatever a legal basis from the proceedings you have chosen to use, the court it brings you to, and decision powers that court has in those proceedings. Let me give an example from Belgium. We have in Belgium, as we speak today, 2 systemic climate cases, 2 climate cases directed against a systemic player. We have the Belgian climate case, which is well known, but we also have the case of Client Earth against the National Bank of Belgium. It was filed in April 2021. They had a judgment, I think the 1st or the 2nd of December or the 31st of November of 2021. And in fact, this case is aiming at the European Central Bank. That's the ultimate goal. And more specifically, a corporate sector purchase program that gives cheap finance to corporations, to companies, and in practice benefits mainly big oil. 2 systemic cases, both in the civil courts, both in the first instance court of Brussels. But the one was just using the regular proceedings. We used the Articles 2 and 8 of the European Convention on Human Rights, and the federal states, the 3 regions, where it was judged that they were violating those provisions. In other words, that the federal state and the 3 regions were violating the right to life of some 58,000 of its citizens. This means each Belgian citizen. So this was rather really strong as a result outcome. The same Articles 2 and 8 were used in the same first instance court of Brussels in a proceedings that where the choice had been made to use a law from 1993 that allows to obtain injunctive relief if provisions of environmental law are manifestly violated, or if there exists the menace of such a manifest violation. The single judge presiding the case just flagged out the Articles 2 and 8 of the European Convention on Human Rights because they were not considered to be environmental law. So just to make my point, I'll leave it there.
Thanks a lot, Carol, for this and ahead of time, moreover. So I will hand over to Sebastian and Francois. Who of you would like to take on this question?
Yes, thank you. Good afternoon to everyone. So sorry not to be with you in Belgium. It would be a pleasure, but we, as many lawyers, we had a lot of work on, and we are disappointed not to be with you, but we are with you through Zoom. So to respond to the questions, I would say first that only 2 lawsuits have currently been won in the field of climate litigation in France. The first one is the Affaire du siècle, called the case of the century, brought against the French government by 4 NGOs. And it was about the fact that the French state had not respected the commitment made in the law to reduce France's territorial emissions. And so the Administrative Court of Paris notes that the French state has exceeded the carbon budget provided in the law. But with Francois, we guess that one of legal basis that should have many perspectives is the law on duty of diligence adopted by the French Parliament in March 2017. And this law provides that requires that parent on ordering companies reaching certain threshold, more than 5,000 employees in France or to 10,000 employees worldwide, have to establish, implement effectively, and publish reasonable vigilance measures adequate to first identify and prevent risk and harms to human rights and the environment, and through their activity, including through the corporate group on its supply chain, both in France and abroad. These obligations have been framed as obligations of means rather than obligation of results, meaning that the companies owing the duty of vigilance will have to mobilize all the resources at their disposal to perform the obligations laid out in the law. The statute should thus have a direct influence on how international corporations covered by the law actually conduct their business and operations. And the vigilance measures have to be effectively implemented and formalized in a document called the Vigilance Plan, which must be published and included in the annual management report of the company. So when this law was adopted, as I said, in 2017, in March 2017, and the first vigilance plans were published in 2018, in spring 2018, just a few months before the publications of the IPCC Special Report 1.5 in October 2018. And then we looked on the Total Vigilance Plan, the first vigilance plan published by the Total company. And we saw that Total did not mention any words about climate change as a risk linked to its activities. And then we sent a first letter to interpellation letter to the CEO of Total to say that climate change is a global risk due to greenhouse gas emissions, which are the consequences of your activities. And then the second vigilance plan mentioned the climate change as a risk linked to Total activities, but we considered that the measures, the prevention measures to mitigate this risk were not enough to prevent it. So, because we considered that global warming would result in serious injuries and losses governed by the duty of vigilance statute, and Total will not dispute this interpretation, given it has integrated these issues of climate change in its second vigilance plan. So we alleged rather substantial breach of the law due to the absence of climate target compatible with the objective of the Paris Agreement to limit global warming to 1.5 degrees. So we guess that this law could be a very interesting legal basis. So the litigation is still ongoing, so we don't know if it will be successful at this stage, but we have we hope a lot about this law, and this is important because in the European level, as you know, there are some discussions on the European Commission as to present a directive on the duty of vigilance in the next weeks.
Yes, indeed. This is a topical point as read also in conjunction with the EU taxonomy regulation, which has just been approved, at least the delegated acts. So thanks to Francois for this overview. I will now turn, Sebastian, sorry. I will then turn quickly to Rhoda Ferrari from Germany.
Yes, hi. Thank you for having me. Well, obviously, it's a difficult question. I've just counted. I've done 6 different lawsuits are still ongoing. 2 of them have already been mentioned. One is the PCC, the People's Climate case in the European courts, and the other is a Neubauer case in our constitutional court. To my mind, both of them were successful. So one was successful in court, and another was successful in actually highlighting a huge gap in the European legal system. access to justice and remedies. So to my mind, those are two actual good cases, which I both consider successful. But obviously that depends on how you actually define successful. I have another case that hasn't been mentioned very much, which is still the only one in the world for some bizarre reason that actually asks for adaptation costs, which is the RWE case, my client in Peru. And I do not know why that is still the case, that it's still the only one. And that case is also very successful, which, and again, I don't understand why it hasn't been copied more. We've won the overall legal argument in, just coughing. We won the overall argument in November 2017. So that's quite a while back. And we're now in the middle of actually using attribution science in court, actually doing what was talked about before in a very, very detailed sense, costing a lot of money in a tort proceeding. So to my mind, that is also a hugely successful case. We've had this issue and the whole of the narrative in court for 7 years now. So, and I mean, in Germany, and I think in international terms, in terms of science and academic discussion, has given people actually something to talk about. So that's quite important. We're now actually going to Peru to look at the laguna and my client's house. We are looking at climate impacts, at actual climate impacts and injustices, which I think is a very big step ahead. And we'll see how the court continues to deal with this case. If we win, I think we need another conference. Nigel nods. Everybody else nods.
Well,
by the way, it's a great honor to be on this panel with all of you. And congratulations on all of the different cases that you guys, were all so important, never mind. So the next one, obviously, that we haven't talked about, which is in court and has only recently been submitted to court, is the claim against Volkswagen, which is modeled around or against, or yeah, a little bit against Shell, but I wouldn't actually call it Shell 2.0 or something, because it's slightly different, because it actually sets off from where Neubauer in our constitutional court case left off. So we're talking about future rights to emit, and the way that each company simply has to observe a carbon budget in much the same way as the state has to observe a carbon budget. So we're actually talking about tons and about approximate carbon budgets, but obviously on the basis of similar evidence than what Roger Cox did in the Netherlands with the Shell case. So we are actually modeling the whole of the applications against the International Energy Agency scenarios, sectoral. I've been approached by at least 10 NGOs to try and do the same case for different sectors. But I don't at the moment see the value in that, because I think we'll have to give the judiciary a little bit of time. But obviously, there are many others than just the automobile companies or the carbon majors that you could actually try that argument against. The other case that hasn't been started properly, but that will be in court, is also very similar to the one that Carol just mentioned, which is financial institutions, the European Central Bank. We are closely monitoring whether or not we can take a case against the German bank, which is supposed to enforce the September new regulation of the European Central Bank to include more climate arguments. And this obviously isn't litigation, but the mere fact that we were able to look at this issue in legal terms, in a legal opinion, made big waves in the German financial papers in September. So this is a whole new set of arguments that is being explored, which is a bit similar to what's happening with the taxonomy. So overall, and I haven't even started to talk about all of the administrative law cases that we've taken. Some of them were a little bit successful, and all of these little installments everywhere. So at this point in time, I would say, if you already have a constitutional court judgment in your country, or if you've already done the ambition target lawsuits, turn to something else. But otherwise, all of these can be successful. And Nigel, I also have about 4 major road projects, mining projects, projects that would be similar to what you did in Heathrow, which are increasingly important to my mind to actually make a carbon budget or climate targets a reality on the ground. So my vote on that first question is we simply have to do all of them because we have no time.
And this is a fair point. Time is actually one of the perspectives, I think, in climate litigation that is kind of overlooked, right? But it is very much important in terms of delivering a fair and equal outcome. So thank you for that, Rhoda. I will, with further ado, turn the word to Sarah from the Netherlands. So what is the perspective from the Netherlands?
Thank you. It's a great honor to join this panel with lawyers whose work I greatly admire. So many thanks for including me in this panel. And two first brief comments. Firstly, Storm Eunice means that I'm doing this from home, but might also mean that there's a little bit of background noise because the wind is just really picking up here, but so sorry for that. And secondly, I wanted to note at the outset that I'll bring more comparative perspective because I'm in fact a New Zealand trained lawyer, but I'm living in the Netherlands and we're assisting at the Climate Litigation Network partners around the world bringing similar cases to the Urgenda case. So on that note, I'll focus obviously on the Dutch cases, but also have familiarity with some of the other cases, the Urgenda style cases in other jurisdictions. But I think there are two obvious, the obvious cases in the Netherlands are obviously the two climate cases in the Netherlands, Urgenda and Shell. But there are two tools, legal tools that I think have facilitated the success of those cases. And the first one is the standing rules in the Netherlands. It has really opened the way for associations to bring public interest claims like the Shell and Urgenda cases. So under the Dutch Civil Code, associations can bring class actions in the public interest. And the courts have recognized that preventing dangerous climate change is a public interest. And in that respect, Urgenda was able to bring the claim on behalf of present generations in the Netherlands. And Milieudefensie was, along with other organizations, was able to bring that claim on behalf of present and future generations in the Netherlands and the Wadden Sea region. So as a result, the Dutch litigation hasn't been affected as much by some of the preliminary hurdles. But I think the key legal tool that underpins both cases is the open duty of care under the Dutch Civil Code, although it's not all that different from other duties of care in other jurisdictions. So I don't think it should be considered particularly remarkable, but how the courts have interpreted it is certainly inspiration for other courts because they've used it as a vehicle to also consider the impact on human rights, and they've done that both directly and indirectly. So perhaps the most simple instance is the Court of Appeal and Supreme Court judgment in Urgenda, where they applied the ECHR directly and then used other sources of international law and scientific insights to define the content of that obligation. So they found that the European Convention gives rise to a positive obligation on the Dutch state to reduce its emissions by 25% by 2020 against 1990 levels. But then if we look at the district court judgments of both Urgenda and in Shell, the courts actually used human rights indirectly. So they considered that there was an unwritten standard of, or there is an unwritten, when they were determining what the unwritten standard of care is, which was binding on both the government and Shell, they looked at various sources. And one of them was the European Convention on Human Rights. And they found that, well, if that affords protection from climate harms, then certainly that needs to be something that they take into account when determining what the standard of care is. And that comes from the Dutch Civil Code refers to the unwritten law that has to be regarded as proper social conduct. So I think that also points to what's been considered the revolutionary aspect of the Shell judgment, which is not particularly revolutionary, where the court said, well, if we're looking at this unwritten standard of care, and given how enormous Shell is and the extent of its emissions, then it's necessary for us to take account of human rights law. And for that, they said, Due to the fundamental interest of human rights and the value for society as a whole they embody, the human rights may play a role in the relationship between Milieu Defensie and Royal Dutch Shell. Therefore, the court will factor this in setting and interpreting the standard of care. So I think with that, we can see the court could look at the IPCC reports and so forth and determine that while for Urgenda it's 25% by 2020, which is now being met and passed. For Shell, that means that they need to reduce their emissions across scope 1, 2, and 3 by 45% by 2030 against 2019 levels. And I think that those two tools, but particularly the open standard, the open duty of care, and the way the court has interpreted that is really an inspiration and has been an inspiration in many cases that had since been brought. So I'll leave it at that. And I think I'm under my 5 minutes, but yeah, I can expand.
Yeah, the bell rang, but perfectly on time. Thank you, Sarah, for this. Of course, the Netherlands is quite insightful in this respect. And I think the issue of narrowing down the scope of emissions for corporations is indeed one of the most appealing avenues in several respects. I will then turn the word to Nigel Plamm for the last response from this first round of questions. So Nigel, the screen is yours actually.
Thank you very much. And can I express my great pleasure to join you. Apologies for my voice. I've got a bit of a cough and I might keep interrupting myself, so I do apologize. And also thank you, Ivano, for that introduction, which makes me feel not only very ill, but very old. And can I start then with this question of legal tools? I've been focusing on the legal tools and legal success. I'm leaving to one side the media success or the fact that there is knowledge arising from these cases. We in the UK have a fairly large number of cases. According to the Grantham Institute, somewhere in the region of 70 to 75 cases. It's difficult to find a success, though, amongst those cases. So in terms of which legal tool has been successful, let alone the most successful, it's difficult to put one's finger on whatever that tool is. I think it's important for everybody to bear in mind that the UK has a statute that underpins the obligation of government, the Climate Change Act 2008. So for over 12 years, we've had this statute which imposes an obligation on government. If I could just read you section 1. It is the duty, good word, of the Secretary of State to ensure, another good word, that the net UK carbon account for the year 2050, a bit far in the future, is at least 100% lower than the 1990 baseline. In other words, the 100% net zero target. That's described as a target duty, but when this statute was introduced with its 80% and then raised to 100% in 2019, the language of section 1 looked like the base for litigation to ensure that the Secretary of State did discharge his or her duty. There are over 100 sections in that act, and there are methods by which the Secretary of State is obliged to reach this target. However, attempts to bring the Secretary of State to court to test whether or not he or she has complied with that duty have been extremely difficult. And one of the reasons and one of the tools is that we don't have a separate constitutional court. Most of our challenges are judicial review, administrative court challenges. And I'll come to this when looking at roadblocks and looking at the third problem, the future. And that is that we have increasingly, it seems to me at the moment, perhaps for small p political reasons, a judiciary that is fairly conservative and is leaving decisions more and more to the exercise of discretion by the administration. This is frustrating for those who are engaged in litigation and frustrating for I think the UK generally. I'll come and deal with a couple of examples when we're looking at the second and third question. But as I've been introduced as having connection with the case in Heathrow, that really illustrates the problem. There are the Court of Appeal is one of the first strong cases in climate change terms in the UK. And one of the issues in that case was whether or not the words government policy in a planning act included signing up to Paris. And the Court of Appeal had no difficulty in accepting that, taking a wide approach to government policy. However, when it came to the Supreme Court, amongst the reasons for allowing the appeal, bearing in mind that the government itself didn't appeal, so this was Heathrow conducting the appeal, one of the main reasons for rejecting the argument in the Court of Appeal is that government policy is to be construed narrowly, and it doesn't include signing up to Paris. Now, that's an opportunity which could have gone either way, and it's discouraging for those of us who are extremely worried about climate change that the highest court in the land went the opposite way to the Court of Appeal. So that's one of my main concerns when dealing with legal tools. There are many examples of where there has been this breakdown. You can see Plan B Earth in a couple of cases. It's all down to this, as I say, to this wide discretion. The other problem is in the UK, and I speak mainly for England and Wales, not Scotland or Northern Ireland, but the procedures are broadly similar. But the main problem is remedies. And the other tool that one is looking for is a tool that has an outcome that will lead to something happening or something not happening. The main area of judicial exercise is the use of the declaration. And I want to come and talk about one case a bit later, but the declaration itself is a pretty useless remedy unless the government body or the whoever's in receipt of the declaration complies with it, or it's framed so precisely that it tells the government what to do in the future. Can I stop there, and I'll come back to this issue, I hope, if you'll allow me, when we get to questions 2 and 3. So thank you very much.
We'll definitely do. Thanks, Nigel, and thanks to everyone for this first round of answers, which were very, very much comprehensive and gave us, I think, us all a lot of thoughts. So I will turn them to Ivano for the second question.
Yeah, thank you very much, Matteo. So our second question is about this. Climate change litigation is only now becoming a straightforward issue to be litigated before domestic courts. However, to litigate climate change still entails procedural and substantive hurdles, which are the main legal, and we say meta-legal roadblocks that envisage in your legal system towards filing, litigating, and eventually succeeding in a claim against governmental bodies or private entities. So let's start with Carol again. We follow always the same order. Thank you, Carol.
Thank you very much, Ivano. With regard to this question, I have in fact 3 points. My first point also joins a comment of Mark Willers, where he said that for a successful climate case, litigation case, you need resilient clients. And money is an issue. Money is an issue. Procedures are costly. And there is a sharp asymmetry in financial means between the classical sides in climate cases, civil society and NGOs and citizens on the one hand, and then the public authorities and companies on the other hand. So indeed, a resilient clients just to keep overcoming that hurdle. The second part, Matteo already mentioned it, it's the time of justice. The time involved in proceedings becomes increasingly an issue. I see this also in the practice we have. Beget started in 2013 and Supreme Court had its judgment in December 2019. This is 6 years. The Belgian climate case started in 2015 and there was a first instance judgment in 2021, also 6 years. And then we have the numbers that Martin did show on his slide that were based on the IPCC report of 2018, stating 1.5 degrees, 11 years, window of opportunity, 1.7, a couple of years more. When you put the time of justice on the scale of this window of opportunity, it is clear that procedures where you can have a meaningful result in a relatively short time span become increasingly interesting. And I'm starting to be increasingly interested in those, thinking of climate. And this brings me to the third point I wish to make. Rhoda mentioned also the administrative caseload. We are seeing in our practice currently environmental permitting cases with environmental impact assessment procedures. And a first thing that has been interesting to observe is that over the past 3 years or something like that, there is a steep learning curve at the side of the competent administrations. They pay clearly more attention to the climate impact of projects with a possible high carbon footing and so forth. But what we also observe in those in that caseload is the total lack of proactive attitude with big companies having an important carbon footprint. Discussing the conditions they could then maybe get an environmental permit, the environmental permit they really need to get operational. They say the reference to technology that might or might not become operational in 2040. And they're just out of where they should stand. There should be something to get them going in a far more proactive way. There is a problem in attitude there. If the big ones would be really more proactive and look for the solution actively, oh, so many smaller ones could benefit from it. So there is something there also that we observe. Thank you.
Yeah, absolutely right. And I think there is also what Professor Michael Ford was saying before about the regulatory capture. And yeah, we'll discuss about this later. Now I just give the screen to probably Francois or Sébastien.
I will
Sébastien.
start with,
Okay.
I will start on Francois. Will continue. So because we identify 2 points on I said as a previous speaker that one important point is the time of justice. In France, a civil trial can take up to 3 years before a court decisions is made in the first instance, then 2 more years for a decision of the Court of Appeal, and finally 2 more years if the case goes to the Court of Cassation. So at least 7 years in total. For instance, the total case was introduced more than 2 years ago, and the debates have so far only concerned the competent jurisdiction to judge the dispute. As we all know, we have 7 years left at the current rate of global emission in the world before we exceed the carbon budget that has been allocated to us in order not to exceed the 1.5 threshold. So I guess that one important point on important difficulty is the proceeding rules on its adaptation to the climate emergency. So I guess that we should collectively use that we must adopt a rule of procedures to the climate emergency, and I guess that it's a very, very important problem. And let the panel to François.
Hi, everyone, and thank you for your invitation. First, I just want to say one word about the administrative case brought against the French state, because to keep some kind of positive mindset, it is the only one case that have been successful in France so far. They have faced many obstacles, and I don't want to be too long on this topic, but it was almost the same question Nigel just raised before. The main question was the issue of enforceability of the targets set by the French state. And hopefully the administrative judge in two cases, actually, one brought before the Conseil d'État, the highest court, administrative court, and the other brought before the Paris court by the affaire du siècle, the case of the century, just ruled that these targets were mandatory. And then the French state has, by March of this year, to take the appropriated measure. Then it shows that even within the French legal framework, it is possible. Because I don't want to be to anticipate too much the counter arguments that Total will put forward, because as Sebastian just said, we are the very beginning, early stage of the judicial proceeding. But in short, we identify many obstacles, let's be clear, relating to the French civil liability provisions. The first is the question of causality, of course, because climate change is a question of multiple emitters. We cannot be it's very difficult to attribute emissions to only one emitters, and let's say Total in our lawsuit. So there is no doubt it will be used by Total as a way to avoid its liability, because classically, as in every Roman civil country, we need to we require the damage, the wrongful conduct, and the causality linked that needs to be direct and certain. And this is mostly the main obstacle we will need to go over. More concretely regarding climate change, there is also an issue with the scope 3 emissions, because at this stage we have no legal binding obligation, duty for private entities to integrate the scope 3 emissions in their climate policy, and it has been at the very beginning of the case, of the Total case, Total was even denying having any scope 3 emissions. Now they are acknowledged to publish the scope 3 emissions, but they are still not exhaustive. And if we imagine some other cases, for example, against financial institutions, or there are other topics that will be addressed tomorrow, for example, the banks, the French banks, which are amongst the most emitting companies within Europe, at this stage, they still have no comptabilization of their scope 3 emissions. It will be for sure the main obstacle. Just a last word, there is also a difficulty regarding remedies, and for the moment, this is why we decided not to bring any court case, and we are mostly relying on preventive or injunction to stop and to limit the harmful consequences. Thank you
very much, François. Thank you very much also, Sébastien. Et on passe alors la parole à... Oh, sorry, I was speaking.
That's okay. I can do the French.
I don't know why.
On passe la parole à moi.
I'm giving the floor to Rhoda. Sorry about that.
Okay, so lots of things have already been said. Francois, we can overcome causation. Don't be pessimistic. We've already won that argument. Please repeat it. But never mind. So you're asking kind of what are the hurdles now? I would like to ask, is it really more straightforward now to go to court? Because have you looked at this? This is the governance regulation. Can you see this? This is a piece of paper. Oh, you can't see it. Here, it's about this thick. It's the governance regulation that comes from the EU. It's climate law. If you take all the climate laws of the European Union together and put them in a folder, you have 3 folders. And all of this will now interact with your domestic climate law. So my take on this question is, it is maybe more straightforward and easier to get to court, but it's also much more technical and much less principle and much less human rights and much less, let's talk about emission. I really think we have to realize this. Whoever does research on climate litigation, please look at the relationship between domestic targets, human rights, and the huge wealth of climate law in the European Union. It is unresolved, and it has especially to do with enforcement. How can we enforce domestic targets, even those set by courts, if we have flexibility mechanisms that are almost impossible to understand? Can I ask this question? Because I know there are lots of young students out there. Please look at this. You know, you cannot apply climate litigation and do it anymore without actually looking at this thing that you can't see because it's a paper. Never mind. So honestly, we have moved past principles in Europe. And Tim, who was talking before, he's in a comfortable position because he can disregard all of this law, but we cannot if we litigate in European courts. So this is the main message that I have from now on. I mean, wherever it has to do with keeping targets, keeping true to targets, trying to litigate on measures, trying to litigate on ambition, we have to clarify the situation between all of this and our laws. It's hugely difficult. I mean, you know, that's the first thing. And obviously the other things, you know, civil law, you know, burden of proof and money were already raised. Obviously, these kinds of cases are very difficult to take. And I think you can differentiate between two things. One is the kind of backwards looking cases, which I would, you know, I would put my RWE case in the backward looking category. We're looking at what's happened since the 1960s and have you contributed to. And those are actually attribution science cases, causation direct cases. Then you have the forward-looking cases, which are Total, Shell, Volkswagen, yeah, all of these, where it has more to do with whether or not judges might be willing to actually go beyond general ideas of what law can do or what judges can do. And that's one of the hurdles I would actually say, how can we grasp our actual carbon footprint in judgments? That is so difficult. And you could look at every single topic. You can look at it from a perspective of the company law and kind of the corporate responsibility cases, you know, scope 3, Francois just mentioned it. But you can also look at all of the sinks cases that come forward now. We haven't actually grasped our carbon footprint in climate litigation in Europe, and we must, because it's huge. And we have such huge governance lack and hurdles and gaps in the countries where our products are being produced or our resources are being mined. And that's the thing that I'm grappling with. And maybe climate litigation isn't so much more needed in Europe now, but it is needed to actually try and come to grips with our actual carbon footprint. That's a huge hurdle in itself, and there's next to nothing out there in research. So again, all of these wonderful PhD students out there, please go and research. Thank you.
Thank you very much, Rhoda. It's always insightful to hear from you. And so we leave the floor to Sarah.
Thank you. Yeah, I think Rhoda's raised, well, all of the panelists so far have raised many of the hurdles. I think focusing on the forward-looking cases that Rhoda was just referring to, one of the issues that we're seeing and now focusing specifically on offender style cases, one of the hurdles is separation of powers or ideas about separation of powers limiting the ability of the courts to assess what states should be doing. And so looking at it from a sort of principled perspective, we see that as one hurdle that's still lingering, and it concerns issues with discretion that Nigel's raised, and also then when it comes down to it, remedies. How much can we ask a court to tell the government to reduce, or be it for a corporation to reduce? And while in the Netherlands, the litigation has been successful in the scheme, comparatively successful, you see the court grappling with this issue. And it's definitely something that's come up also in the broader discourse around the judgments. So the court, openly acknowledged that the decision-making on the reduction of greenhouse gas emissions is a power of the government and parliament, and that they have a large degree of discretion for that. But the court stepped in to say that its role is to assess the limits of its, whether it's exceeded the limits of the law. And I think that's a nice way to frame, or a positive way to frame this separation of powers issue, because really that's what we're asking courts to do, is to sort of look at where those limits are, and human rights provide a good compass for that. But then to be successful in those arguments, we need to be helping courts identify the standards that they can use. And Luc Labrison earlier mentioned, it's not for courts to say how they're going to do it, but they can draw on, objective standards. And that's really where we need to see a little bit more work, because there's a lot out there. There are a lot of standards that courts can draw on, but we need to make that very, we need to help courts ascertain, what that is, and where they can therefore be comfortable setting the minimum. And we're so far off the minimum, particularly in Europe, that minimum is, the standards are there to show that the governments are doing, are grossly shirking their legal responsibility. But I think just a few words on that. While in the Urgenda case, they used obviously the fourth assessment report to find the 25%, but also referring to COP decisions and so forth on that. In Shell, the court relied on the global average. And some have since said on that judgment that the global average, that the 45% that the court relied on was arbitrary. But we've now seen that picked up in the Glasgow Climate Pact. So we're seeing political consensus, coming onto this sort of IPC 1.5, SR 1.5 pathway. And so obviously, though, we then have the additional layer of complexity that global average isn't really appropriate to apply to European countries, when European countries need to be doing considerably more than the global average, which then brings in considerations of equity and common but differentiated responsibility, and the need to take the lead, which these countries have committed to doing. So one report that is interesting in this respect, and we're seeing this in the Italian case and the Polish case, and I understand we'll see it in the Duarte case that's coming before the European Court of Human Rights, is these reports that Climate Analytics has put together, which show the equitable contribution of the given country in light of scientific standards. And those reports build on the IPCC methodology, which aggregate effort sharing methodologies, and then they find a target that the government or the relevant government should be doing. And in the Italian climate case, that was set at 92% reduction by 2030 for Italy against 1990 levels. So it's a huge reduction, but that's really shows what these governments should be doing, and it's building those standards so that courts can have something that they can hold on to set the remedy, because without the remedy, without there being an order, a reduction order, these cases And I think we saw that, and Carol can probably speak to this in the Belgian climate case. That was disappointing because there was an illegality, but ultimately we're looking for the courts to uphold that legal duty and issue a reduction order. So I'll leave it at that. To say that, yeah, it's a challenge, but it's surmountable, and it has been surmounted, but we can continue working in that space.
Thank you very much, Sarah. It was really, really interesting. And I give immediately the floor to Nigel. Nice to see you. You have the floor.
Ivano, I'm conscious of the time ticking rather quickly. This is such an enjoyable event. It could go on, as far as I'm concerned, for a long time. But that means I'm going to be very short on question 2 to leave a bit of time for me to address this, the use of human rights in our climate change world. And one word on what Rhoda just said about EU law. At the moment, the UK is temporarily missing from Europe, and it's a little difficult at the moment in the UK courts to develop some of the arguments that are being developed throughout Europe, just temporarily. I want to mention just these obstacles. First of all, on filing, I think we're in a much better place than we used to be in terms of access to the courts by pressure groups and representative groups. That's been the situation since the 1990s. So for me, the main obstacles are costs, not just the cost of bringing the litigation, but the risk to litigants of costs. In our system, legal aid is rarely available, and unless there is Aarhus protection, individuals or even groups, or in my case, local authorities, are at risk of paying the cost not only of the Secretary of State, if it's a government challenge, but also, and rarely, when it's in my case, Heathrow itself, or in the other cases where it's a major industry paying the third-party costs. So that's a challenge. In terms of the meta-legal, I've mentioned this already, but as far as I'm concerned, and those who I often speak to, climate change litigation is so important that in terms of the very existence of life on our planet, that it needs judicial nurturing, and it needs judicial encouragement. But so far as I see here, there is a burgeoning education amongst our judges, but there's not just at the moment that encouragement to make litigation as easily as possible and as cheap as possible and as quick as possible. The thought of having a 5-year case on litigation, which is closer to the end of the earth, just seems to me offensive. There are many examples, but could I just take from judicial review one other roadblock, and that's our test of rationality. When it comes to the exercise of discretion or judgment, the courts will not interfere unless the exercise is irrational. And that's such a high test that the courts regularly just duck the issue. I'll stop there, Ivano, because I wanted to leave one point for when we deal with question 3.
Thank you very much. It was perfect, and you helped us a lot also with timing. So, Matteo, the floor is yours.
Thanks, Ivano. Thanks to all of you. I think we are learning a lot here, and we're getting very, very valuable insights. I have plenty of questions, but I'm not going to ask them now because we have one already on the table. And the one being whether looking forward, in light of your insights, your experience in courtrooms, in your own jurisdiction, of course, what do you see as a potential legal and meta-legal, even more importantly, avenues for climate change litigation, of course, before domestic courts to A, enhance the chances of successful outcomes, then of course we will have to debate about what successful means, and B, to ensure that strategic litigation prompts concrete action by governmental and private entities, as well as to raise public awareness and mobilization against climate change. So this is a big question, and you will still have 5 minutes to answer. So I turn the word to Carol now.
5 for everybody? Okay, this has to go fast. What I'm seeing in my practice belongs to the realm again of environmental permitting. We have, as we speak now, several cases of pending environmental permitting demands of companies with a high carbon footprint. And in parallel with the learning curve of the administration, discussions popping up in those in the administrative stage of handling of the cases before the judicial stage, but they were not there a couple of years ago, is the scope 2 and the scope 3 emissions. Do we have to include them in what are indirect impacts to take along in environmental impact assessment reports? And they're really clearly and very distinctively formulated in the administrative stage. Now, it is new. And if those cases could go to the judiciary, and there could be a preliminary question to the European Court of Justice, what a difference that would make if the outcome was positive. And there are no standing problems because the standing goes together with the administrative proceedings. It is low level, low thresholds. You do not have enforcement problems because the permit will maybe not be given, or and well, that is something I see potentially when looking at changes in discussions in environmental permitting for high carbon footprint activities trying to get a permit. And it would, I think, make a very nice judgment if it could come, and a very good outcome. And then the other point maybe also answers on a comment Sarah made. There is this triangle between human rights violations, especially the right to life, which is a hard Notwehrfestige. The German has a word for that. Notwehr, Rhoda will tell me. But it are the Notwehrstandige rights. There is a triangle. Those rights are really coming up, and there is no discussion anymore that substandard climate policies of public authorities and of companies are really also an issue of human rights. It's getting absolutely accepted. There is this, and then there is this separation of power discussion, where we heard Justice Lavreysen say that some consensus seemed to be emerging, that as long as it is a general target and not the how to the target or the goal, that might go. And then, of course, there is the issue of the effective remedy, enshrined also in the Article 13 of the European Convention of Human Rights. If there could be something there where the right to an effective remedy could somewhere stop the obstacle of the separation of powers, just saying, look, there is only one way to solve this violation of human rights. And the single way is mitigation with a certain minimum for a certain time in 2030 or something like that. That would be an interesting development, as I see it, from the Belgian frustration where we had violation of human rights and nothing coming next. Where I have to make also the point that there is also an element of legal culture, because in Germany with the Neubauer case, there was the statement that there was a violation of human rights and there was action taken within a couple of weeks. Whereas in Belgium, this absolutely was not the case.
Thanks for that, and thanks for raising the point about legal culture, which is indeed one of the key issues when it comes to comparing a little bit across legal systems. So I would turn the word to France, then I don't know if Sébastien or Francois, maybe Francois is taking on that. So Francois, the screen is yours.
Thank you. Thank you. First, thanks, Rhoda, for your support. Don't worry, we are not giving up, and we keep being optimistic because, in short, we've been identifying a lot of new avenues to bring and to overcome the obstacles from the old civil legal system. First, I think the first one is not legal even. It's more, yes, meta-legal, or call it whatever you want. It's because the mentalities are changing so quickly on climate change, and the way we are now realizing that we are facing maybe the most biggest challenge of the century is even in France, even for judges, bringing some new insights and new perspectives. The first decision we obtained on the total case was a decision not on the merit, but some kind of procedural issue. But even for a procedural issue, the judge wrote some kind of ruling we have never been seeing before. He was very going on the principles and asserting that that climate change needs to change and to change the way we are considering our law. Then I think this is the most important perspective for the perspective on climate change and fighting or bringing and winning a lawsuit. The others are more legal, and I think that one interesting point is that companies and most polluting emitters are in some points making our future successes. Because I want to talk about the voluntary pledge and commitments to be net zero in 2050, to be carbon neutral. And we definitely need to take them by the words and to bring these commitments in front of the courts. That's why we believe the French duty of vigilance law is pretty well adapted, because as Sébastien just described it before, it is relying on the knowledge and the control that big companies have over their supply chains, but also the control they have on their emissions and the commitments they are taking. That's, from my view, the easier way to bring them against their responsibility on climate change. And the last point is something that we can discuss together as Europeans and even with our UK colleagues. I definitely think there is something to do with the directive, the EU directive on the commercial unfair practices. And I point the commercial announcements on carbon neutrality, being carbon neutral, net zero, which are most of the time just greenwashing. And we believe that there are some spaces for bringing cases on these legal grounds, criticizing, challenging the ads brought by carbon majors, banks, and all the biggest polluters.
Thanks for that, Francois. Indeed, the issue of greenwashing is popping up in my very country, which is not Belgium, actually, my birth country, which is Italy, actually. But this is maybe something full for discussion later. So thanks for that, Sébastien. Sorry, Francois. I will turn the word to Rhoda. Please, Rhoda, the screen is yours on this point.
Thank you, Francois. That was, yeah, some of the points that I actually had on my list as well. I think I'll just have 2 points then. One is, I actually think we need to enforce targets and the integrated energy plans in each member state. Because if you look at the flexibility, this doesn't include the UK now, Nigel, I'm sorry. Because if you look at the flexibility mechanisms, you can actually buy from everyone all the time and with no limit. And we actually don't know how much there will be to be bought at all. If you look at the impact reports, I would assume that there's actually nothing to be bought, at least starting 2026. So, and this is a huge issue because, I mean, we all see now how the Commission had struggles to enforce EU law. So, and if we just leave it to the Commission to enforce it, we'll be sitting in a Europe which will be a laughing stock globally because it will not actually meet its targets. And I am very afraid that that is going to happen unless we find ways to actually enforce member state targets. So that's something that really affects my thinking currently. The other is linking biodiversity crisis and climate and finding standards. Sarah was already talking about standards. When you look at other planetary boundaries and which are in conjunction with climate, that is biodiversity, the first one that you would, you'd kind of come to. There is no standards that we can actually readily use, and that's not good, because there's been a question by Annalisa on the LULUCF regulation and the new targets there. The linkages between biodiversity and LULUCF and natural sinks will become ever more apparent in the next couple of years. And we need to find ways to actually make that accessible so that we don't win one battle, which is, find programs to have natural sinks, but lose the other, which is biodiversity strategy. So that's the other thing that really concerns me currently. And I haven't been, anyone who has a good standard for biodiversity for complaints, be them administrative or constitutional, please come my way. I haven't been so far, haven't been very successful. And the third thing I should say is these conferences have focused very much on the strategic cases, the ambition cases, as I call them. Urgenda has done a hugely wonderful job, and I love you all, but we need to do the project cases too. Otherwise, we will never be able to actually get the ambition on the ground. And there's huge battles to be fought also in each member state. And what Carol just said, I can only give you a glimpse. What I'm looking at currently is hundreds of cases where communities are trying to come up with new ideas to be very attractive. And they come up with new industrial sites, new surfing alleys, new things that use a lot of electricity. And we have an Energiewende in Germany, which is we're not there at all, and we need to be efficient, but that hasn't permeated anywhere. So we're not even looking at coal companies or gas plants. We're looking at things that will use so much of our renewable energy that we will not get our climate targets in order. And that's something that we haven't talked about at all anywhere in these conferences. But I think that environmental lawyers in member states will have to face these things. And that's dire because it's a lot of work and it's very detailed, and often you cannot transplant them in the same way as you can maybe with Urgenda type human rights arguments and stuff. So I'm concerned about that too. Not sure I can solve it all. I'll continue to try. That's it.
We should continue trying, and thanks for putting this in a very much to perspective here. I do like the point you make on consumption of electricity. Where do we get this? Anyway, I will just then turn the word to Sarah now, because we're very much into time constraints here. So Sarah, please, the screen is yours.
Thank you. Yeah, I think it's important to flag so the kind of what looks like the next, what will be the next big legal action in the Netherlands. And that's, I think we've seen from Urgenda, as Rhoda was sort of alluding to, Urgenda has been very successfully replicated in other jurisdictions. We now have about 40 Urgenda style, or whatever you call them, ambition or systemic mitigation cases in other jurisdictions around the world. And that was also, obviously, Roger Cox was the lawyer in Urgenda and then went on to bring the Shell case. And that was successful. And I think we can now expect to see more Shell type cases in the Netherlands. At least that's what Milieu Defensie has indicated that it intends to do. So they have in January sent letters to 29 CEOs of the 29 biggest polluters in the Netherlands, indicating that they need to produce a plan of how they're going to reduce their emissions by 45% by 2030 on their 2019 levels. So that's citing the figures that were included in the Shell judgment, and they've given them 3 months to do that, and then we'll see what follows. So I think if the Urgenda judgment was served as a template, then we can expect the same for the Shell judgment. And then as for other potential avenues, we're also looking at, and we expect to see people challenging. I mean, we are focused on ambition. We know all the tools in the legal box are required, but in relation to that, there's the pathways. A lot of countries have come out with net zero targets, which, great, net zero in 2050, but they're not indicating, or they haven't set 2030 or other intermediate targets that are even remotely on track to achieving net zero. And net zero in 2050 is premised on us following a certain trajectory downwards, which we're not on at the moment. And I think Neubauer, alluded to and also the case in France, alluded to the importance of interim targets. And now we need to start sort of pushing them. And I think there's a real scope for people or organizations to hold countries accountable for their so-called, great climate targets. And so in the emissions gap report, they indicated that the targets, the net zero targets, are currently vague and not transparent. But if they are met, and they are met in a kind of in the necessary manner, then we could bring global warming, or we could limit it to 2.2 degrees Celsius. That's obviously not enough, but it's considerably better than what we're on track to warming at the moment, which is closer to 3 degrees Celsius. So yeah, I think the pathway is one also to look out for, to close that accountability gap. But I will hand over. I know we're short on time and it's Friday night and people want to yeah.
Yeah, it's Friday night indeed. And thanks for that, Sarah. And I will then turn the word for the very last answer by Nigel to wrap up this third round of questions. So Nigel, please, this is yours.
Thank you very much. I'm going to start as I have been a little pessimistically, but then I'll try and end with a brighter note. In terms of avenues, what's been happening recently in the UK, in light of Agenda and Royal Dutch Shell, is to try and bring human rights-based challenges into our domestic litigation. And the arguments are well formulated, well presented, but so far it seems that they're not yet judicially enthusiastically embraced. Let me give you one example. It's another Plan B Earth case, and it's a 2021 case, so quite recent. And the judge there refused permission to challenge, so didn't even get over the first hurdle. And having rejected arguments under the Climate Change Act, the judge then turned to Articles 2, 8, and 14, nice combination of articles, and said, what you're trying to do is enforce Paris through these articles, and that's impermissible in our international law regime. But the way that the judge refused permission is really interesting. So if any of you can access the case 2021, the case of Plan B Earth, paragraphs 48 to 51. Let me just read you a few lines. The insuperable problem with the Article 2 claim and with any Article 8 claim based on physical or psychological effects of climate change on the claimants, there's an administrative framework to combat the threats posed by climate change in the form of the 2008 Act, and the policies and measures adopted under it. So that was the block to Article 2 and 8, that there is this framework. And he goes on and says that the approach is to leave this to government, and that reflects the constitutional separation between the courts, Parliament, and the executive. And that keeps coming back over and over again. And the other example on my negative side, then I'll be really positive, is the case I mentioned in passing earlier. It's nothing to do with climate change. It's a pollution case. And it's, again, very recent. The Court of Appeal gave judgment on the 17th of January this year. And the case is called, or the name of the claimant is Matthew Richards. And this was a case that came before Mr. Justice Fordham last year. And it's a pollution case where the impact of hydrogen sulfate emissions from landfill was accepted by the experts to be such that it would be significantly reduce the life expectancy of the young claimant. The judge at first instance made an order, which you can see in paragraph 64 of the Court of Appeal. And what he said he was trying to do, quote, was secure practical and effective human rights standard protection. And he made a declaration, but this is one of the first declarations I've seen, which is in positive forward-looking terms, a bit like the Pakistan case dealing with climate change. And he says he orders the Environment Agency to comply with its legal obligations and then set out how that should be done. The Court of Appeal roundly says, no, you can't do that. And it ends in, it's a really interesting judgment to read. And it ends, the declaration which required the appellant to achieve prescribed outcomes within a prescribed timetable, memories of the Pakistan case, went beyond the scope of the court's functions in dealing with a claim that the appellant was, etc., etc. So beyond the scope of the courts. So that's the depressing news. The good news is that the duty of care element in Royal Dutch Shell is beginning to be picked up in discussions in the UK. I've not yet seen it take all the way to trial. There's Ewan McCockey is a case that's running, but that's a case where the pension fund was the claimant. And what we're seeing is the emergence of these challenges to companies, not to the governments, such as shareholder proceedings we've seen in Poland, now coming to the UK. And in the UK, we now have a task force on climate-related financial disclosures, and that's on its way. And failure to disclose the effect of investments by companies, that's also coming in. And only a few days ago, the medical profession objected to the giving of licenses for North Sea development. So there might be a whole new raft of human rights cases, but brought by medical profession rather than by individual claimants. And so I end with a smile on my face.
That is great, Nigel. Right on time and with a smile on our faces as we wrap up this session. So my heartfelt thanks to all of you for all the insights you have brought to us. Again, we have learned a lot from different jurisdictions in Europe. So before we indeed wrap up, since we're already late, I will just go for a quick round of questions. So we will just first pick up, of course, the questions on site, and we have plenty of questions actually already online. So I will just open the floor for questions in the room to all our distinguished guests here. And if nobody has questions, we can then turn to online. But I see Marianne Peters has one question.
Thank you very much. Indeed, my name is Marianne Peters from Maastricht University. Thank you so much for the panel, for all these interesting views. I would like to invite you to reflect a little bit further on the relationship indeed between EU climate law, the massive regulatory action undertaken by the European Union, the wealth of regulation, I think that Rhoda Ferrari said. It is a complex body of regulation indeed in relation to litigation. Do I understand the panel correctly that we have seen a climate litigation for setting targets, for setting more ambitious action, but that perhaps in this decade, the emphasis will be on enforcement, and particularly also enforcement of EU climate law. Let's take the EU ETS as a main instrument. And in the first panel, there was a quite positive reflection on that instrument. But if I look at the legal literature, and if I also look at the case law across the European Union, I hardly see attention to, for me, a very important question: is there sufficient compliance currently by the main emitters in the European Union with this EU ETS, which has a cap to reduce the emissions across this decade? So it's not possible to buy everywhere you want, because there is a limit on the total amount of emissions, and that limit decreases. So I am worried about compliance with the law that we have. And I wish I would see some litigation there or investigations there as well. So that's a bit a cry from the heart, actually.
So we are turning again to the sad note. I see Rhoda raising her hand, so maybe she wants to follow up on this.
I absolutely agree with the assessment. That's exactly my assessment. I think given the new climate law and the intermediate targets that are in there, and the extreme amount of regulation and monitoring and inventarization and LULUCF new targets and whatnot, there is a huge task for enforcement actions. And the ETS example you just gave is a very good one, because what we see currently is an energy market which is fueled by old ETS licenses, which were brought and bought very cheaply. That should have never happened. And yeah, I agree that there's very little enforcement on this. And it becomes more complex, of course, if you go into the other sectors and actually look at the new instruments there. As I said, it'll become much less sexy and much more technical, which is a bit of a problem.
That's appealing for headlines, but probably more down to business, right? So does anybody want to take on Marianne Peter's questions in the panel? Just taking a look at the windows over there. Carol? Any further questions for the audience inside? On site? Wow. Raising hands. So please take them in turn, and then we can take one online, and then we can wrap up. Please state your name, full name, because the panel won't see you.
Hello, my name is Andrew Maglica. I'm a PhD student at the University of Milan in Italy at the University of KU Leuven in a joint PhD program. I would like, first of all, to thank the organizing committee and all the speakers also from the previous panels, because it's been really a very wonderful afternoon, and there's been a lot of food for thought, so thank you very much. Among all the several questions which come up to my mind, I would like to ask you about the kind of relief which is being sought in courts, because I kind of noticed that there's a lot of actions which seek injunctive relief. But my question is, why do you think that there's not so many actions which are seeking damages? Like, for example, in the Lulia case, which is kind of an exception, we could say. Obviously, there's the issue of causation. It's a problem to demonstrate that the connection between the harm done and the defendant. But don't you think that compensatory actions could have also a deterrent effect? Thank you very much.
Collect them for the panel part.
Yeah, hello, and thank you to all panelists for the insights. My question is about, again, ambition, litigation, systemic cases, and the issue of standards and fair share. So I think Sarah was pointing out that in cases like Neubauer, the claimants are asking to follow standards that are not in line with international justice or with international law when we consider the historic responsibility of developed countries. There have been recent studies that have said that if we would have to consider these fairness issues, developed countries such as Germany and France would have to stop emitting by 2030. So I'm wondering how you think this gap between justice and this minimum in human rights litigation can be filled with future cases, maybe international litigation, or so on. Thank you.
Can you state your name, please?
Oh, sorry, I'm Carlotta Garofalo, and I am a PhD candidate from the University of Graz.
Thanks a lot. Okay, the floor is open. Who wants to take on these two quite challenging questions? I see Rhoda's hands. I see also Carol's hands. So, Carol first.
I'll take the question of the young gentleman there with regard to injunctive relief. I speak for the people of Klimaatzaak. They simply are not interested in damages because what they want is to safeguard a part of future. Go through all this mess and this hardship of litigation and just to have damages for the past. it's not interesting. They want to safeguard a part of the future. And there are legal technicalities one could add to options between damages and injunctive relief, because it doesn't litigate in the same way in the courts. But the option basically is an option for the future.
And time comes again. Rhoda, please. And then Nigel, I see also.
Yeah, I think that's a bit of a narrow understanding of damages, right? Because my case doesn't actually ask for damages, it asks for adaptation costs. And that's, you know, you could do that in about a zillion cases in overall global contexts. I don't have an answer to that question. I started off with saying that I don't know why that is, that we're still the only one. I do say that it's very costly. And obviously we're up against one carbon major, and they've just bought satellite data for the glacier that we're looking at for 250,000 euro. And and they're now, you know, putting that in court against us, which hopefully won't work, but that's the kind of eye level that isn't there. So yes, that might be a very good reason in practice. I would like to say one word about the justice issue. I think apart from the statement that every country has to do its fair share, all of the ambition cases have actually not looked at justice. And the Constitutional Court in the Neubauer case hasn't either. There are some very interesting remarks in the overall text of the judgment, which lets me believe that actually the court would have loved to talk more about our actual carbon footprint, also in historical terms, but they couldn't. The division of power issue really at that point. So I would actually say if somebody could come up with a case where this could be grappled with, and there are some legal standards that you could actually use rather than the very diverse standards that are in the Paris Agreement, it is necessary to do that because, yes, we're all aware that the per capita approach as of now is actually very unjust. Very, very unjust. Right. So, but I haven't read a single judgment that actually took that on. The Commission on the Right of the Child actually did a partially good job in looking at why every single human being is protected by every single state, at least. And that also is something that our Constitutional Court recognized. But with respect to actual what is the fair share?
Right, thanks, Rhoda. I would turn the word to Nigel, and then I would take the last question online, and then we will wrap up. Nigel, please, the screen is yours.
I'm not going to deal with adaptation costs. I'm just thinking of costs in the, damages in the terms of tort law. And the reference I made earlier to Royal Dutch Shell and the possible use of duty of care brings into play in the UK courts the potential for damages-based claims, whether it be negligence, nuisance, or some other aspect of duty of care. What we've had recently or fairly recently in the UK is a spate of cases which are on behalf of either employees or persons affected around the world where the head office is in London or in the UK. So you get a representative claim on behalf of hundreds of thousands of people or thousands of people against the head office. And that has been operating mainly in pollution cases. And there is now, I think, some discussion at least about such cases being brought in the, I think the right phrase is climate change space. So I think that's going to be really interesting. And one or two of those big cases may then attract insurance companies as hidden defendants. And if they have not got exclusion clauses in place, there may be some pressure on companies by insurers to make sure that standards rise. And amongst those standards are compliance with or assistance in minimizing greenhouse gases or the effect of their activities.
Thanks a lot for that, Nigel. I see Sarah's hand is up as well. I don't know if you have a very quick point though, like 10 to 15 seconds. I'm sorry for that.
I was only from Carlotta's question about fair share, but I think Rhoda has covered it, and Carlotta's on my panel tomorrow, so we can follow it up. But I think it really comes down to the fact that it's a really difficult strategic question. I think all of us that work in climate change and are familiar, with the climate change regime and the huge justice issues in this, it's a real tension of what we go for and what we encourage our partners to argue. And then the tension with what we believe that the court is going to accept. And that's a tension that we're constantly grappling with. And that's also why we're trying, and I think Rhoda touched on it, why we're really keen to develop these standards which take into account these legal principles that increase, that take into account climate justice, because it's a pretty, the difference, the gap is very big. But I look forward to discussing it more with Carlotta tomorrow.
Thanks, Sarah. I think, Ivano, we have time, 2 minutes for a quick question online, and then we need
just the last question online. So it's from Andreas Hosley. What are your thoughts on the public-private divide as far as climate change litigation is concerned? For example, most fossil fuels entities are actually not private, but state-controlled entities. So I don't know who wants to respond to this quickly. Thank you very much.
Rhoda, perhaps?
I can try. I don't think anybody has plans to actually put an application to court against Kuwait Oil. I think that's the easy answer to the carbon majors list. But I mean, the Volkswagen that we're actually now taking to court on a due diligence duty of care obligation and nuisance, right? Which would be the same sort of law that could be applied anywhere, is also actually partially state-owned. So many companies that are large are actually partially state-owned. You'll have to look in your own countries. So, if that's an answer.
Thank you very much, Rhoda. Thank you to everyone for these wonderful contributions. Also from my side, I leave now the floor to Carol for a very short concluding remark. I'm really sorry.
Well, first, before that, I will ask for a big round of applause for our guest speakers here. All online, I hope you can hear the clapping. We ran late, but I wish to thank you heartily for sticking around. I see the screen in your, the windows are getting gloomy in your screen, so it's definitely late, but it means that we had a lot of food for thoughts. So thank you very much again. And then I will turn over to Carol for the just closing remarks, very briefly, before we head to our reception and afterwards for dinner. So thank you very much to all of you for participating in this roundtable and for accepting to participate in this conference.
Matteo and Ivano, thank you for this last panel. Just a couple of concluding remarks. What stays with me after this afternoon is the discussion about what is success, that it is such a nuanced discussion with many aspects that go really beyond winning a case, not winning a case, and that somehow give a better image of what climate change litigation can reach as results and how it works in society. And then the other point that stays with me is the insistence on the layers of climate change litigation with the important symbolic, iconic cases everybody reads about in other continents and so forth somewhere, and then going down to the cases of the projects of companies, bigger companies, but also smaller companies and smaller small-scale projects at the local level. And just to englobe all this in the vision of what climate change litigation should be and take along when being discussed. So far for this key learning points, and I speak for myself for this afternoon, then there are a couple of practical communications to give. First of all, regarding tomorrow. As you know, the day tomorrow will start with parallel sessions. I will not enumerate them. Time is short as we are there at the end of the afternoon. But I want to insist on the fact that the sessions will start at 9 a.m. sharp. So for the online participants, please be online at 8:45 Central European Time. You have chosen your session and will automatically be directed to the matching breakout room. For the on-site participants, please go straight to the room where your workshop happens. The room numbers are indicated on the program you have in your bag, and they will on the board there will be directions to help you find that room. Once again, we will definitely be online at 9 a.m. So this is for tomorrow. As for this evening, we have for the on-site participants, and I'm sorry for the online participants, we have first this reception in the cafeteria. You know where it is. We had coffee there. And then for the on-site participants who will attend the conference dinner, I think most of us are staying at the Holiday Inn. We will be there at 7:15 and just help you towards the restaurant if ever you feel it's necessary. And that will be it. Thank you so very much to all participants of today and who made the afternoon. Thank you.